who's not present today. I just want to bring something up for you folks to talk about. Yesterday, we briefly talked about when to do the closing arguments, and I'm just going to ask you folks to discuss it amongst yourself what your preference is. My preference now, after thinking about it, would be to do it at the conclusion of this hearing. The simple reason being that this hearing is going to end. It's going to take probably 3 or maybe 4 weeks to get the transcript in, and then there's going to be briefs on it. So to schedule a hearing before the entire commission might not be for another 6 or 7 weeks, which would make it difficult, I would assume, to make a closing argument when it's fresher in your mind today. But I'll defer to the parties. So why don't you discuss it amongst yourself and let me know what your thoughts are. And then if there's a disagreement, I'll just make the call. Okay, yeah, Ms. Burke. Yeah.
Would that be with all the commissioners here?
No, if it's before me, it would.
So that's the preference.
Yeah, my preference would be to just get it over with. However, if you want to argue before all of the commissioners, I should note that, you know, at least 2, if not 3, my commissioners have been listening in. Sure. So they have been listening. And if it's a closing argument, I would assume they would endeavor to do it, but I'm not sure.
Well, I'm on for what it's worth, I'm on board with that.
Okay.
We would not be submitting briefs then, it would just be the.
You can submit a brief post-argument. That's entirely up to you. You want to do it, fine. You don't want to do it, fine. Yeah, Ms. Pruitt.
Thank you. As the petitioner noted on the record yesterday, we want to have the briefs. We want to do the closing argument before the full commission.
Okay, that's understandable. So let me just solicit. So I have Mr. Burke on one side of the equation, you're on the other side. And Ms. Kiley, do you have any initial thoughts what you want to do?
As yesterday, my preference generally is to close at the close of the hearing before the hearing officer. And that would be my preference here.
Oh, okay. Ms. Rusconi, you have a...
My preference would be to do it in front of the presiding.
Up in front of me at the end of the... Okay, yeah.
My thinking is that when the petitioner rests, which I understand is going to be today,
Right.
All the evidence involved in Travers will be completed.
Correct.
And so I'd like to do my closing argument and my brief as early as possible. I'd ask the chair to think about the question as to whether, in fact, the decision about Mr. Travers could be reached earlier. I mean,
Okay.
if the evidence is closed, why wait 7 or 8 weeks?
Okay. Okay, let me take that into consideration. Obviously, all of the evidence isn't closed because the defendants are going to put on some evidence and something may arise at that point concerning your client. I don't know, obviously, but I don't want to foreclose the petitioner from, from hearing all the arguments and then making the argument. Would you make your argument from via Zoom, I would assume?
I'd probably do a short brief that, as I've always said, I thought the case against Mr. Travers turned on 2 witnesses, him and Mr. Keenan, and we heard from them. I expect petitioner to rest today. And if this wasn't a consolidated case, it'd be done with Travers.
Okay, well, let me take that under consideration and we'll talk about it a little more tomorrow and I'll make the decision. Okay, thank you. And Ms. Pruitt, the floor is yours, unless one of your colleagues is going to be conducting the direct. Okay, thank you.
Good morning, Commissioner Candice Pruitt for the petitioner. Petitioner calls Judge Despotopoulos to the stand.
Okay, thank you. Good morning, sir. Would you raise your hand and do you swear to tell the truth, the whole truth? So help you God.
I do.
Okay, thank you, sir.
Good morning, Your Honor. David Sullivan, on behalf of the trial court,
Okay, good morning to you. And as we did yesterday, at any juncture, sir, if you want to consult with your attorney, just let me know and I'll take a break and allow you to do it. And sir, if you want to consult with your client, just let me know and we'll take a short break to allow that. Okay, thank you. And ma'am, the floor is yours.
Good morning, Judge.
Good morning.
Could you state your full name for the record and spell your last name?
David Philip Despotopoulos, Despotopoulos.
And you're represented by Attorney Sullivan. correct?
Yes,
Have you listened to any of this adjudicatory hearing?
yes, I did.
What did you listen to?
I listened to portions of the testimony of Chief Justice Dodd.
Why?
I like to get a lay of the land.
Objection, I mean, Judge, this is for witness, I don't understand, the question, why?
Well, I assume that he's gonna answer it and we're gonna move on. So,
He did, so
so he just said, his answer was, he wanted to get the lay of the land. Next question?
What do you mean?
Prepared. I've never been involved in one of these hearings. And just to get a sense of what this room was like.
Are you able to hear him? Okay, great.
I'll speak up.
A little softly. You speak a little softly. Will the testimony you heard impact your testimony this morning?
Not at all.
Did you review anything in preparation for your testimony this morning?
Yes, I've read the transcript of my interview by the Attorney General's office as well as listened to the audio of that.
Have you ever served as an assistant district attorney?
Yes,
Where?
at the Worcester District Attorney's office.
When?
1985 to 1989. And then 1996 to 2001.
So about 9.5 years?
So 9.5 years.
And during your time as an assistant district attorney in Worcester County, how many times do you recall redacting an arrest report or probable cause complaint to remove a defendant's own statements?
I don't recall that I ever did.
How long have you been a judge?
A little more than 20 years.
And when were you appointed to the bench?
I was nominated, I believe, at the end of June 2001. I was sworn in on August 22nd, 2001.
Could you please describe for the commission your judicial assignments?
Currently, I'm the first justice of the Worcester District Court. I am the regional administrator of justice for Region 5 of the District Court, which comprises Worcester County and one court in Middlesex County, which is the Model District Court. Prior to that, I was associate justice of the District Court. Basically, for probably the last 18 years, I sat almost exclusively in the Worcester District Court.
Have you sat in any other courts?
I've sat in every court in Region 5. I've sat in a number of other courts throughout the state.
What are your duties as the first justice of the Worcester District Court?
I'm the administrative head of the district court in terms of I set the room assignments for the other judges, which is basically in charge of making sure that we have our sessions are staffed with judges so the work gets done.
What are your duties as the regional administrative justice?
Sort of similar, but on a larger scale. I'm responsible for 24 judges in the region, 11 courts. I make sure that the courts are staffed with judges. We would take scheduling, I approve vacations, sick time, all that. I'm responsible for implementing the policies of the district court, the chief's office, as well as the trial court.
In terms of busyness, how would you characterize the Worcester District Court?
We are on paper the second busiest, but I like to think we're the busiest. In terms of volume of cases, Springfield has more cases than we do, but not by many.
Directing your attention to October 2017, when did you first learn about the arrest of a judge's daughter at issue in this case?
A little bit before 6 a.m. on the 17th of October.
And how did you learn of her arrest?
I received a text message from her father.
And what did the text message, and what was in the text message?
He informed me that his daughter had been arrested, that he was going to take her to get some help, take her to a hospital, and that he needed coverage for the Dudley District Court where he was working at the time.
And is that why he texted you, because he needed coverage?
Yes.
What, if anything, did the judge say about handling his daughter's case?
Objection.
What's your objection?
I don't think we've had a conversation established at all.
Okay, well, it's, no, she can have, you know, you can have the question.
In that first text, I don't recall whether he did say what he was gonna do.
What do you say in the next text?
He texted me a couple hours later to tell me that he got a bed for her, he had a bed for her, I believe a ad care, that that he was just gonna get her help, just default her, and that after she was released from the hospital, he'd bring her in and plead the case out,
And what did you understand to plead the case out to mean?
resolve it.
Resolve it how?
I offer a tender plea.
What happened next?
Not sure what you mean.
After you were done texting Judge Bebo, what did you do
I-
next?
Before I finished the text with Judge Bebo, I asked him where was the arrest, because at that time I did not know.
Right? And what did you do next?
He told me it was in Worcester. So eventually I went down to the clerk's office to speak to Mr. McKeon, to see, try to get information. I asked for, at that point, the arrest had not arrived yet. And I said, well, I would like to see a copy of the docket complaint application when it comes up.
Why did you want to see the docket and the complaint application when it came in?
To see what we were dealing with. I knew that because the case was in Worcester, Judge Bebo sat in Worcester occasionally. We were all colleagues of his, friendly with him, but the case would need to be transferred out of Worcester District Court. So I needed the information because eventually I was going to have to notify my chief's office.
Did you receive a copy of the complaint application and the arrest report?
I did.
Did you read it?
I did.
Did you have a reaction to the arrest report?
I reacted to some comments or statements attributed to the daughter in that report.
What was your reaction?
Bothered me
Why did it bother you?
because the statements I knew were going to be embarrassing to her, her family, her father. And as a father, I knew how it would bother the father and the rest of the family. The comments were embarrassing.
What about the court? Would it be embarrassing to the court?
Objection. I don't think he's a professional witness as far as it calls for a conclusion or an opinion as to what the court entity in and of itself would be embarrassed by.
Well, given his role there, he can answer the question.
May I be heard on it? I think the question had been, how did he react? It bothered him. And now we're going into whether it bothered him for a reason other than that he articulated.
You know, I understand that, I appreciate that, but give her some leeway.
Well, I think as in my role as the first justice in the RAJ, Regional Administrative Justice, that it could have an impact on the court and how the court was viewed. And it turns out that the media, after this came out, it was embarrassing for a lot of people.
What happened after you read the arrest report?
I think I went to work and took the bench.
Did you have any communications with Judge Alec Madaus?
I did.
Can you speak up, please, Council? I'm sorry. I just gave you.
Yeah, I
No,
agree.
actually, I
I'm
was
just
talking
having
to
some
Judge.
trouble hearing you too. Could you just speak up a little louder, please?
Did you have any communications with Judge Alec Madaus?
Yes,
When did you communicate with Judge Alec Madaus?
sometime that morning.
We're still talking about October 17th, 2017, is that right?
Yes.
And why did you communicate with Judge Alec Madaus?
He's a friend of mine. We work together closely. I ran into him in the, we have a little kitchen where we get coffee. He was in there when I walked in. I spoke to him
What did you speak with him about?
about the daughter's arrest.
And did you share the arrest report with him?
I don't know if I shared the report with him or told him what was in it. I don't recall.
What was his reaction?
Similar to mine.
What is your understanding of how the state police criminal complaint applications differ from, say, those of the Worcester Police Department?
Back in 2017, I don't recall whether they were filing them electronically at that time. If you're getting at the difference between a Worcester Police Department statement of facts and a state police statement of facts. So in the complaint application, there's an application sheet where they write the names of the suspects, defendants, whatever you want to call it, and then what the charges might be. Then they support that with a statement of facts. The Worcester Police Department, if you see their statement of facts, generally speaking, it's a gist. They put enough facts to meet the elements of the crimes. The state police, they file a more thorough statement of facts. I consider them statement of facts. You're calling them a police report. What the difference is on the state police report or statement of facts is if you see the first page, it starts in the middle of the page. Because I believe the top part is where the biographical or so it's booking information would be. I think that's the difference. It pretty much mirrors their police reports.
So the state police arrest report narrative mirrors the probable cause statement
From my
in the
experience.
criminal application.
Yes.
Yes, okay. After you spoke with Judge Alec Medaus, what did you do next?
I think I went to work, frankly.
Did you communicate with Judge Dolly?
On the 17th, no.
Did you call Judge Dolly's office on the 17th?
I did.
And who did you speak with?
Alan Shapiro.
And was this after you spoke with Judge Alec Medaus?
I believe so.
All right. Who was Ellen Shapiro?
At the time, she was the deputy court administrator.
Why did you call Ellen Shapiro?
Because she was in the chain of command. I called her so she would inform Judge Dolly
Inform Judge Dolly of what?
of the judge's daughter's arrest.
Why?
Because that's part of my job.
Why did Judge Dolly need to know about the judge's daughter's arrest?
One, because he's the boss. I think it's important for me to keep him informed. But more importantly, I was going to request that the matter be transferred. He's the one with the transfer authority.
What was Ellen Shapiro's response?
She told me she'd inform the chief.
Did she agree that the case should be transferred?
I'm sure she did. I'm sure she does. She does.
When did you first speak with Judge Dolly?
It would have been the next day.
So this is October 18th?
Yes.
And why don't you tell the commission about that conversation with Judge Dolly on the 18th?
He called me. We discussed the transfer of the case. He asked me how Judge Beaver was doing. We talked about transferring the case, I believe, to Middlesex County at the time. I don't recall whether at that time he told me which judge would be handling that.
After your communication with Judge Dolly on October 18th about the case being transferred to Middlesex, did you share that conversation with anyone?
I think that night, I texted Judge Bebo to inform him the case was going to be transferred.
When was the first time you communicated with District Attorney Early in any manner regarding the arrest of the judge's daughter?
That would have been on Friday,
Friday, is that October 20th, 2017?
yes.
And how did that communication come about?
I was sitting on the bench, our arraignment session. I noticed the district attorney walk into the courtroom. I don't know whether he made a gesture, I don't know but I realized that he wanted to speak to me. So I handled a few more cases when it was appropriate to take a recess. I took a recess. I think I just called him in.
What happened next?
We started talking.
What did you talk about?
Initially, I believe we talked about, we had had a prior conversation about a program in Essex County having to do with the opioid crisis that the district attorney had been to. He'd come to me maybe a couple weeks before, asked me if I would be willing to take a tour of this program because he was hoping to start a similar program in Worcester County. He was asking me, and he was going to ask the Raj or the Superior Court also, and at least legislators, because he was going to try to convince the sheriff to start this program. And almost simultaneously, that's when Brendan McKeon showed up.
If I could just ask you to pause for a second. You said that you'd had a prior conversation with the district attorney about bringing a program into Worcester County that mirrored a opioid treatment program in Essex County.
Yes.
Correct.
Yeah, objection.
What was the question?
I hadn't gotten to my question yet.
Okay, why don't you just ask the question and then I'll hear Mr. Bourgeois. Okay, ask the question.
Right. So you just testified that you had a prior conversation with the district attorney prior to October 20th about having a opioid program in Worcester County similar to the one in Essex.
And I
Correct?
renew my objection. She's leading her own witness.
Okay, well, it's, that's overruled.
Is that correct?
Yes.
All right. What was your conversation with him on October 20th when you invited him into the public lobby?
I believe initially that's what we were talking about. Because there was at some point, there was a date that he had told me beforehand wasn't a good date, I guess, and we were talking about what was going to be an appropriate date or a date that we could agree on.
What happened next?
That's when Brendan Keenan showed up. We were probably in the lobby for 30 seconds before Brendan showed up. It was like almost immediate.
And what happened next?
Brendan mentioned that First Assistant Travers had come to him regarding the report, that that Brendan was not going to allow Mr. Travers to, had asked about changing the reports out. Said he wasn't going to allow him to do that.
Changing what reports out?
The reports of the judge's daughter's arrest report.
So changing one report out for another report?
I don't know what their conversation was.
Sure. What was your understanding of what Mr. Keenan was relaying to you?
Objection. The judge has indicated that he was not privy to the conversation.
Okay, you can answer it.
Do you need the question read back?
No, I don't.
Okay.
My understanding is yes, when you say, can I change this with that, that's taking one and putting the other one in, yes.
And what, if anything, did District Attorney Early say?
He said, can we change them out? Brendan, wait for your question.
What happened next?
Mr. Keenan said, you can't switch them out because the original was what the probable cause determination was based upon.
Why wouldn't you allow the District Attorney's Office to change out the arrest report that was on file for a different arrest report?
It wasn't a different arrest report, first of all. It was a redacted report. The district attorney early informed me that it was redacted. The here, Brendan Keenan informed me that it was redacted. There's a difference there.
Okay, why wouldn't you allow him to do it?
I have to object. This is seeking, this motion was ruled on, motion to redact was ruled on. This is getting into judicial deliberation. Why the judge made the decision that he did.
Yeah, I agree with that. Okay, that's overruled.
There's another reason for it.
That's sustained, yeah.
There's another reason.
Yeah.
He hasn't indicated that he was specifically asked to swap them out. It was the conversation between Jeffrey Travers and that of Mr. Keenan.
Okay, well, I've sustained the
I do,
objection.
but it doesn't mean she's not gonna ask another question pertinent to the same area.
Okay, and then I assume you'll object, then I assume that I may sustain again, so.
So if I may, I'm actually not asking the judge what he did with respect to the motion.
I'm just asking you to just ask another question.
At the time that Brendan Keenan appeared in your lobby regarding what Assistant District Attorney Travers wanted to do, you'd already reached out to Judge Dolly about transferring the case, right?
Yes.
And did you have any concerns when Brendan Keenan appeared indicating that the district attorney's office wanted to make changes to the report?
May I have the question read back?
What's that?
I may object. I want to have the question read back.
Okay, can we have the question repeated, please, Madam Court Reporter?
And did you have any concerns when Brandon Keenan appeared indicating that the district attorney's office wanted to make changes to the report?
Objection.
I'm sustaining that.
What did you say in response to District Attorney Burley's statement, can we switch it out? What was your response?
Objection.
No, that's overruled. He can say what he said.
What did I say?
Yes, what did you say?
I said, we're not gonna switch them, but I will allow you to file the redacted report.
And what was your understanding of what would happen with the original report?
The original report was gonna stay in the file.
Would it be under seal?
It was impounded at the time.
Did District Attorney Early mention that he had a revised arrest report from the state police?
No.
Not at any time?
Not at any time.
Not in any of your communications with him?
My only communication was that time.
How often does the district attorney visit you during your arraignment session in the second busiest courthouse in the Commonwealth?
Well, it was at least that one time.
In the arraignment session?
In the arraignment session, at the time, prior to that, I was sitting in a different session. I was sitting in the arraignment session that day because I had a new judge with me, who I was training. But the district attorney has come to me prior to that. At the time I was first justice for about 2 months, right? He had come to me a couple times one about the issues I already talked about Essex. There was another occasion in which he came to me to tell me that the Mass DA's Association was no longer going to offer the breath testing and operating under influence cases.
In the arraignment session?
Oh, that was in a different room.
Okay, so not in the arraignment session.
Right.
Okay. And in this instance, he appeared in the arraignment session to discuss a scheduling matter, is that right?
I think he appeared in the arraignment session because that was the session I was sitting in.
What happened next?
What happened next? District attorney left. When McKeon left, I went up to my personal office.
And what happened next?
Eventually, I called Chief Justice Dahl.
And this is still on October 20th.
Yes,
Why did you speak with Chief Justice Dahl?
to inform him of my conversation with the district attorney.
Why?
Because I'm required to keep my chief informed. I had taken steps to remove the case from the Worcester District Court. And I wanted to inform him that the district attorney had come to me and that they've asked me to basically file the redacted report at this point.
What happened next?
Conversation ended.
And then what happened?
I went back down to my office is on the 4th floor. I went back down to the 3rd floor to take the bench.
And what happened next?
And I observed Mr. Travers and Mr. Keenan. They were sitting in the conference room, which is right at the bottom of the stairs, or they were standing outside.
And what happened next?
I had a short conversation with Mr. Travers. He indicated that he had the redacted report. I saw the redacted report. I didn't hold it, but I saw it in his hands. He explained to me what portions that he was redacting. And I said, okay, let's go in the courtroom and put us all on the record.
Now, as a judge, can you recall another time when the first assistant district attorneys appeared before you on a misdemeanor OUI alcohol drug charge?
Nothing stands out. I can't. Could have been. I don't know.
You don't have any recollection?
No.
Okay. And as a judge, can you recall another time that the first assistant district attorney proactively moved to redact the arrest report or criminal complaint of an arrestee to remove his or her own statements?
Objection, Your Honor. There was a stipulation, and there is no question that there's no allegation against my client in the probable cause statement concerning anything after his initial conversation with Mr. Keenan. And apparently, at this late date, petitioner may be trying to change his theory, but that's not fair after Mr. Travers testified.
No.
They've stipulated it, this is what they pleaded, they never amended it, and it's too late for them to be changing their theory.
Okay, well, I'll consider it at the appropriate time, but he can have the question.
Do you have a question with that?
I do.
And as a judge, can you recall another time that the first district attorney proactively moved to redact the arrest report or criminal complaint of an arrestee to remove his or her own statements?
I don't recall.
What happened next?
We went into the courtroom.
And then what happened?
I heard some cases.
What happened after that?
Mr. Travers made an oral motion.
And what was the oral motion?
Order asking me as the court to allow him, or the district attorney's office, to file the redacted report.
What happened next?
I allowed the motion.
And what factored into your decision to allow the motion to redact?
Same objection, Your Honor.
That's sustained.
We have a moment, Commissioner?
Sure.
I have no further questions for this witness. Thank you, Judge.
Thank you, ma'am. Ms. Burke?
Morning, Judge. Morning. I'm Tim Burke, and I represent Major Susan Anderson. Have you and I ever met before?
Not that I recall.
Have I ever appeared in front of you before?
Not that I recall.
Do you know my client?
I may, I'm not sure.
You play Scrabble?
Objection.
No,
Well,
well,
What the word salacious means?
I do, I'm not gonna define it for you, but
Okay, well, that's why I asked the preliminary question. You looked at this report, didn't you?
yes, I think I described it as salacious.
Any disagreement that the content of those statements, those three statements that were ultimately redacted, revised, removed, switched out, whatever the phraseology is, any doubt in your mind, given your experience as a former prosecutor and as a judge, that those were salacious?
I've already said that they weren't.
Okay. I want to reaffirm that. And you know what probable cause is, obviously.
Yes.
And during the course of your evaluation of that, did you look at the police report, the first 7 paragraphs, and I'll submit to you that there were 9 paragraphs in that arrest report.
I'm gonna object.
well, let me finish the question and then I'll hear you. Okay, thank you.
Would you be able to determine whether or not in the body of those first 7 paragraphs, the officer who made the arrest was able to demonstrate the existence of probable cause?
I'm gonna object.
And your objection is?
This witness has provided no testimony that he reviewed the arrest report for probable cause.
He doesn't have to review it for the purpose of probable cause.
It's okay, yeah, he's just asking a general question about whether those 3 statements add to probable cause. Okay,
First 7.
okay.
The first 7 paragraphs,
I don't know how many paragraphs were in the report.
there were 9.
Do I have a view? I do have a view. Whether I'm gonna share that with you, I'm not sure.
Okay.
Only because I believe it goes towards my allowance of the motion.
Okay. All right, so I'll move on to a different question. Do you know what the professional responsibilities are for a prosecutor having done the same job? Specifically, Rule 306 and 308?
In general.
And do you know whether or not a prosecutor, especially a person in a senior prosecutor position, has an absolute responsibility under those rules to ensure that pretrial publicity is not in existence or present in a prosecution that their office undertakes?
I agree with that.
I'm sorry?
I would agree with that.
Okay. That's their affirmative obligation, isn't it?
I would agree with that.
And when you were asked whether or not that's ever happened before, District Attorney Travers, do you know what his function is within the office, Worcester DA's office?
He's the first assistant.
Would you agree with me that that person has added responsibility to ensure that prosecutions of all types within the District Attorney's office are done properly?
Yes.
And when did you know that there was an impoundment of the original police report?
Probably, probably. I learned about that on October 17th.
And the impoundment itself, and we've gone through this previously, but an impoundment does what?
It shields whatever that is impounded, the document, from view, from
How about from public view?
public view. The parties can view it. Can be unimpounded.
Okay. Let me ask you, when you learned that this was impounded, Joe Early didn't ask for it to be impounded initially, did he?
As far as I know, he did not.
Jeff Travers didn't ask for it to be impounded, did he?
As far as I know, he did not.
It was done by the defense attorney for Ms. Bebo, isn't that true?
That's my understanding.
And wasn't there a written motion, handwritten motion that was filed in accordance with what is done in impoundment cases, right?
That is my understanding.
And wouldn't you agree with me that a judge, whoever it was that heard the impoundment request, the motion that was filed by the defense attorney, can impound it, cannot impound it, or make whatever decision that they want to make, right?
Yes, within the judge's authority.
Okay. And would you also agree with me that there are certain prerequisites that are required to be met before a judge can appropriately impound any document, including an arrest report?
There are requirements, yes.
Okay, and is there any doubt that Judge Locke, when he allowed that motion to impound, did so based upon what was represented to him in open court?
I have to object, that calls for the conclusion of the other judge, I object.
Okay, that's fair enough. So that's sustained.
The motion to impound was allowed, was it now?
As far as I understand it, yes.
And are you familiar with the requirements of the impoundment rule? I think it's Rule 8.
In general, yes.
We're not trying to quiz you today about your knowledge of the rules, but does the impoundment order, the impoundment rule require that there be notification given to the other side of the case? In this instance, the state police?
Once it's impounded, yes.
Okay, they have to be given notice of that, correct?
Right.
And do you know if that was done here?
Frankly, I have no idea.
And your conversations with Judge Bebo, did you learn at some point in time that the charges that were brought against Ms. Bebo, that they were ultimately admitted to sufficient facts on all of those charges?
I don't know if I learned that from
Okay,
the judge.
did you learn it at some point in time?
Yes.
Okay. So there was no difference in terms of the actual charges that were initiated against her that she ultimately pled guilty, admitted to sufficient facts to.
No.
So nothing about these revisions altered the nature of the charges to which she ultimately admitted to sufficient facts.
I agree with that. The revisions, the motion to redact is not a dispositive motion. It's not a substantive motion. It doesn't affect the charges at all.
Exactly. And when this was brought to your attention, and again, feel free to object, that you made a decision based upon the information that was available to you in open court, right?
Yes.
Objection.
What's the objection?
He's asking about the decision that the judge made.
Okay, just repeat the question, please.
I'm not interested in your thought process.
I understood that.
I'm just interested in whether or not, based upon what was presented to you, you allowed that motion to revise the original arrest report.
No.
Okay.
I did not allow anybody to revise the original report. What I allowed was for the Commonwealth, the District Attorney's Office, to file a redacted version, the original still in the file, in its original form.
So the original was still impounded, wasn't it?
Yes.
That never changed.
No, it was. No.
Okay. Now, did you know at any point in time about the interaction between the arresting officer night that Ms. Bebo was arrested and his interaction with the bail commissioner?
I'm gonna object.
If he doesn't know, he doesn't know, so,
He is exceeding the scope of direct.
well, he's allowed to do that. Okay, okay.
I don't understand anybody owns a witness, it doesn't matter if something exceeds the scope of direct. They
I
don't
know.
own this witness, do they?
No, I overruled the objection.
Did you understand my question?
If you're asking me, did I become aware of something that happened at the barracks? I think, yes, and I believe that I became aware of that when I read the Attorney General's report.
Okay. Did you agree with the redactions that were made by the district attorney? Okay. Nothing more, thank you.
I have, once again, some of my fellow commissioners are listening in, and they occasionally have a question, so I'll ask the question, see if you can answer it. Mr. Burke, I'd ask you to remain up
Oh, sure.
there because you may want to have a follow-up question. This is a question from one of my fellow commissioners. Was the statement that my father's a judge salacious? I mispronounced it.
No. No.
Okay.
Well, again, Judge, if I ask questions pertinent to that, it goes into his mindset, so I think I'll leave it where it is.
Let me, another question.
Actually, if I can,
Sure.
is the basis for a motion to redact solely predicated on something that's salacious? Is there more, Judge?
What's that?
Is there more questions?
Yeah, there's just one other question. Have you ever had a similar case to this that garnered the media attention that this case did?
Where I've been involved in cases that garnered media attention, yes.
Okay.
Yes.
Okay.
But to this extent, no.
Okay.
In this particular matter.
Okay, thank you, sir.
Does the level of media attention in any way correlate to ethical conduct?
Ms. Kiley.
Thank you.
Thank you, sir.
Allow me to reintroduce myself. Tom Kiley, and I represent Joe Early. The last question related to media attention. The first piece of media that you became conscious of occurred when?
I don't recall the date. I think it was the next week.
It would have been Friday, the 26th, as reflected in the
It was
testimony.
Thursday or Friday. I think it was Friday. Maybe it was Thursday. I don't remember.
And it was in a blog or some kind of,
Yes,
and it was salacious,
yes,
and it was, as you described it in the interview that you reviewed before, it was crazy stuff, correct?
yes,
And the media that followed was more of that crazy stuff, correct?
yes.
And now I'm going to go back to the beginning. When you first learned of the arrest report on the morning of the 17th, at some point somebody brought you from the clerk's office what has been described as the arrest report, correct?
Yes,
And you read it and you thought it was awful, correct?
yes,
And you then communicated with Judge Alan Madaus about it, correct?
yes,
And Judge Alan Madaus reacted and said, Jesus, they put that in here? correct?
Words to that effect.
Now, your next action, as you've testified today, is to communicate with Ellen Shapiro.
Yes,
And in dealing with Ellen Shapiro, you indicated, did you not, that you needed to talk about the different things that could be done to get that out of there?
no,
You reviewed, did you not, for your testimony today, your testimony before the Attorney General's
I
office?
did.
And that occurred on December 8th of 2017.
I know it was in December 2017. Don't recall the exact date.
Within a relatively short period of time after the
Yes.
2017 document. I'm sorry. After you first saw the document. I'm going to be referencing to page 1933, I believe. Do you recall indicating, I let Ellen Shapiro know? I said it's a first but it was, whatever it was, the first offense OUI, what the charges were, and that the report will we have to talk about different things to get the language out. Do you recall seeing that in the
I
interview?
recall seeing that, I recall reviewing that yesterday. I had talked with Attorney Pruitt on Tuesday. She brought that to my attention.
You just don't recall saying it then?
No, but by reviewing it, and if you read further down, my further answer, what I was doing there, I believe I said straighten out the language. And it didn't, obviously it's typed differently. I was trying to get on the same page with the AG's office of what we were talking about. I refer to these things as statement of facts. They were referring to it as a police report. If you read further, that's what I explained about the complaint process. I never said, we're gonna get that language out of there.
Was there a discussion about impoundment on that initial morning, October 17th?
With me,
Were you involved in a discussion about impoundment on October 17th?
at some point I was told either that it had been impounded or that the defendant was moving.
Did you meet with Judge Locke on the morning of October 17th?
Yes.
To let him know what he was dealing with,
Yes.
what he would be dealing with? Was there a discussion about impoundment at that time?
No. Not that I recall.
I'm going to go to the back end of the paper now, if I may. You've testified, and it is the case, that there's nothing unusual about impoundments, correct?
Other than, of course.
And there's nothing unusual about redactions, correct?
No.
They're an
I agree.
everyday event in the courts, correct?
I don't know about every day, but yes.
You don't do them every day, but there's something
Somewhere
happening
along the
in the
way.
court somewhere every day on redactions, correct? There are rules that require papers here and in the courts to be redacted, correct?
Yes.
And they're laid out, are they not, in again, the rule of the court that deals with public access to materials, correct?
Yes.
I'm gonna pretend I'm organized. I want to fast forward from the 17th, really fast, 3 days to the 20th. That's, the 20th is the first time you had any discussion with District Attorney Early, correct?
Correct.
And on this subject. You had talked with him previously about other matters.
This was the first time, that was the first time I spoke to him that week.
And on that occasion, he came to you to talk about a program, and that's what you were discussing, correct? Scheduling a meeting.
That's what I thought he was coming to see me about, yes.
And in that conversation was between the two of you.
Yes,
And then Clerk Keenan appeared,
yes,
close, proximate in terms of time.
yes.
When Clerk Keenan appeared, he was not accompanied by First Assistant Travers.
That was just myself, Mr. Keenan, and Mr. Early.
And Mr. Keenan stood at a respectful distance and then approached when you were at a lull in your conversation.
Frankly, I don't remember.
And in terms of the actual conversation as it started with Clerk Keenan, did he strike that? Was there any reference to District Attorney Early making any asks of Clerk Keenan?
No.
Mr. Early, District Attorney Early, had not asked you to do anything with respect to the matter of the judge's daughter, correct? At that point?
At that point, no.
And Clerk Keenan brought up then what his interactions with First Assistant Travers, correct?
Yes,
And made a statement about what he could not do, correct? Or would not do. And do you recall the exact words the District Attorney Early then responded with?
what's the effect of, can't we just change it out, something like that?
So I'm again referring to the document that you will have used to refresh yourself. And I'm going to refer to page 1973. You recall reviewing the material, correct?
Yes.
And again, you used words to that effect as we just answered.
Just wait a second.
Yeah, can we just wait for a second? Just wait for
Just have a hard
the
time hearing.
music in the background.
Wasn't me.
I
think we can do it now,
I think, I think the music has subsided. Mr. Kiley?
Do you recall, let's strike that. I'm going to read two passages to you starting on line 1. It was right then at that point that he said that I represent his District Attorney Early. Will you do that? Question mark. Or something, whatever the words were. And then 3 lines later, Early requesting, yeah, can we do that? Or whatever, something, whatever that was. And I said, no. That sound right to you?
My testimony? My
Yeah.
statement? Yes.
You were asked. Somebody brought a subject up. Mr. Early asked whether it could be done.
Right.
The answer was no.
Right.
And there was no pushback on whether it could or should be done.
No, that was the end of the conversation in terms of that.
And you never were asked to do anything to about a revision, correct?
Never.
Word revised was not used with you in any of the discussions. In this one discussion that you had, was there any further discussion or did the word swap ever come up?
Swap? No, I don't believe it did.
Were you asked by District Attorney Travers, First Assistant District Attorney Travers? Sometimes first assistants can be presumptuous and treat themselves as district attorneys. Did District Attorney Early ask you to do anything at all?
First assistant?
Oh, District Attorney Early at that point. My question was District Attorney Early.
You've lost me here.
Okay,
Sorry.
let's start over.
What are we talking? Where?
District Attorney.
District Attorney.
I make first assistant jokes all the time.
Okay.
I'm sorry.
That's okay.
The District Attorney Early ask you to make redactions?
Did he ask me to make redactions? No.
Did he indicate he would leave the question as to what should be done with First Assistant District Attorney Travis?
I think that's what, I don't remember whether he said that or whether that's how it worked out.
And then did he absent himself for further discussion?
That's what I'll separate.
You never had a discussion with both District Attorney Early and First Assistant Travers at the same time, did you, on this matter?
On this matter, no.
You made a contact afterwards, after the conversation with First Assistant Travers with Judge Dolly.
I don't recall that.
Did you call Judge Dolly to discuss the matter? I should say Chief Justice Dolly. And did you call Chief Justice Dolly on the 20th?
On the 20th, yes.
Was it to discuss what you were going to do, consider a motion?
Yes.
So is the first time that you knew you were going to be considering a motion when Brendan Keenan came to you and informed you of a desire to file a redaction motion?
I'm not sure I follow you. I had a conversation with District Attorney Early and Brendan Keenan.
Stop you.
Yes.
That's in the afternoon, you know,
Heard sometime in the afternoon.
when you had gone back into the arraignment session, having been in there earlier in the day as well.
I was in there the whole day. Yes.
It was in the afternoon.
Yes,
after you-
so we had a lunch break between 1 and 2, went back on the bench at 2 o'clock, and then somewhere thereafter, the district attorney came to the court.
That's the first time when he came into the courtroom that you had any, like that. There was no discussion when he came into the courtroom about redaction, revision, impoundment, or anything of the type in the court.
No.
Your conversation then with the district attorney in the area outside of the courtroom was about scheduling, correct?
Initially, yes,
And then Mr. Keenan came and you had a further discussion, correct?
yes.
And following that discussion, did you contact Judge Dolly?
Yes,
to
that's
tell
when
him what was?
I called.
Okay. I just want to get my sequence straight.
Scully, I think your associate may want to
And I'll wait till he's done.
wait.
Thank
Okay,
you.
thank you.
So thank you though, Judge. Did you discuss then with Judge Dolly, Chief Justice Dolly, what you intended to do?
Yes,
And it was that you were going to allow the motion, correct?
yes, yes,
And you did allow the motion
yes,
on the merits.
yes.
Objection.
That's, well, he can have it. He's educated.
You were not asked by First Assistant District Attorney Travers to do anything that you thought was inappropriate? Or you thought that strike that, the district attorney was exercising, the office of the district attorney was acting properly in asking for redactions, correct?
Objection.
What's your objection?
Acting properly goes into his decision on the motion. He's
Yeah,
making
yeah.
a determination.
Yeah, I noticed that Mr. Sullivan did not have and do you object to that question, Mr. Sullivan?
I understood the question to be directed to whether the motion could be brought, as opposed to any deliberation.
Okay, I think he had a follow-up question about the propriety of that, so which
It was
I tend to agree with the petitioner,
Thank you.
frankly. So I'm going to sustain that objection.
It was within the rights of the district attorney's office to ask you to redact the documents, correct?
I agree with that. A party can make a motion, either allowed or disallowed.
And a motion to be made ex parte as well, correct?
Yes, in terms of redactions, yes.
But in this case, the district attorney's office was the prosecuting office, correct? And they were a party, correct?
Yes.
And the party has a right to seek redaction, correct?
Yes.
And with respect to the disciplinary rules, a prosecutor has a special responsibility, correct, to avoid prejudicial pretrial publicity.
Yes.
And the statements that were redacted could result in prejudicial pretrial publicity, couldn't they?
They did.
Okay, thank you. Yeah, I was going to go to Mr. Bourgeois first, but if Mr. Rosconi, if you want to do.
Want to go first, or
Sure.
the applicant? Oh, okay.
Okay, Mr. Rosconi? Thank you.
Good morning, Your Honor. My name is Mike Rusconi. I represent retired Colonel with McKeon, who's not present today due to some family obligations.
That was on my notes.
I practice primarily in the district and superior courts in the Commonwealth. I make it to Worcester once in a while. I don't recall coming across you, or I assume you don't recognize me. Just want to draw your attention to something, and I'll preface this. My questions will seem mundane and basic with respect to the criminal process. There are commissioners listening that don't necessarily have a criminal background. I believe these questions will assist in their understanding of a day-to-day court procedure. So if they do seem very basic, just bear with me. You referenced that when Judge Bebo texted you, there was a conversation that his daughter was going to be in a hospital, right? For getting help.
Yes.
And he said just default her.
Yes.
Can you explain what that means, just default her?
When a person's arrested, if they're bailed, they're generally told to report to the courthouse the next day. And if they fail to appear, they will be defaulted. So a warrant can issue for their arrest.
And once a warrant issues, if that person should be out in the community and an officer recognizes that person, or if they're driving and their license plate comes up on a scan and shows there's a warrant outstanding, that person will be taken into custody,
Yes.
taken to a police station,
Yes.
and then shipped to the courthouse where the warrant was outstanding, correct?
Yes.
So Judge Bebo basically, in layman's terms, knew that a warrant could be issued for his daughter after that conversation, correct?
Yes.
He did not ask you to not issue that warrant.
He did not.
And you didn't handle the arraignment, that's fair to say, right?
I did not.
But you've handled plenty of arraignments in your time, right?
Yes.
And you'd agree with me that it's not uncommon if somebody provides verification that they're at a facility for rehabilitation, that arraignment will be continued.
It's common.
And in this case, to your knowledge, is that what happened?
Yes.
So this is nothing out of the ordinary.
Nothing at all.
So if a homeless person was arrested and provided information that they were at care or any other facility, that person's arraignment could be continued.
Could be and generally is. I mean, I know we're coming out of the pandemic and we really haven't talked a lot about the opiate crisis, but at the time, and still ongoing, there were almost on a daily basis, people asking us to continue their clients' case, the lawyers asking us to continue their clients' cases because they were in a program or in a hospital. It was common course.
Of course, thank you. Now, you'd also, and again, I don't want to get into the specifics. I'm sensitive to that you made rulings regarding this case, but I will ask, in your time as a judge, you presided over several DUI-related trials, whether it be motions and jury trials, bench trials.
20 years?
Yes.
Yeah, more than several.
Yeah, that's what I figured. So you're, I'm sure, very familiar with the model criminal jury instructions, are you not?
Yes, I have.
And the model criminal jury instructions have a basis in the statute, correct? In that they address elements laid out in the statute.
Yes,
Now, would you agree with me that those jury instructions are written and based on case law and statute, correct?
yes,
And those are to assist a trier of fact into what they can and cannot or should not consider in a trial, correct?
yes.
And with respect to OUI, there are 3 elements to OUI, and those are operation, public way, and impairment. Is that fair to say?
Yes.
And as far as impairment, if it's an OUI drugs case, there are different evidentiary standards that need to be met to prove impairment, correct? As opposed to alcohol.
Yes.
For example, in an OUI drugs case, there's no breath test, right?
Correct.
Rarely a blood test, but sometimes it can come up, right? And you'd agree that even if a blood test does come up, it can be difficult to prove impairment for any number of reasons, which we won't get into.
OUI drugs, that's correct.
And OUI alcohol, there's the per se law, which is if you are a blood alcohol content of 0.08 or above based on either a blood draw or a breath test machine, correct?
Correct.
And just briefly, at the time you referenced that DA early said that they weren't going to use breath test machines going forward at that point, correct?
That's correct.
And that's in reference to litigation with respect to suspension of the breath tests due to some serious issues with the record keeping by the Office of Alcohol Testing, correct?
Yes.
And at that point in time, there had been no final decision with respect to in the future if those tests would come in. It was possible that they would eventually become valid again, correct?
I believe they are currently. Yes.
So at the time, he was suspending the use of them. And in fact, the trials themselves were being pushed out, waiting for that decision to be made, correct?
Some were, some were not.
So some cases would proceed without the breath test if the defense attorney or the prosecutor in those particular cases decided it was appropriate to do so, correct?
Correct.
Now, as far as impairment goes, and I believe this is rooted in the model criminal jury instructions, that even possession, absent certain circumstances, does not necessarily suffice to show impairment, correct?
Correct.
Now, would you agree with me that the method by which somebody obtains a substance has absolutely no bearing on whether that person is impaired or not?
I agree with that.
And again, you've been admitted to practice law for about as long as I've been alive. So, that's no slight to you, trust me. And you've reviewed several OUI reports, have you not?
I would say so.
And in your career practicing law as both a judge and as an attorney, have you ever seen a statement like the ones being discussed included in an OUI report with respect to how that person acquired a substance?
I don't believe that I've seen one in the same sense that was in this case, but I have seen police reports that had what could be determined salacious or embarrassing comments.
And sometimes embarrassing comments may go to probable cause, correct?
Yes.
Right. And but as you said, the way it was used in this sense, you have never seen an OUI report with a statement like that.
Not that I recall.
No further questions.
Ms. Bourgeois?
Sure, just two things. Could I please have exhibit number 6? And could I also please have a copy of the rules of professional responsibility I gave you yesterday? We have.
Okay.
Exhibit 6 should be the motion to impound.
Right, here you go. Here you go.
Thank you very much.
Sure.
Thank you. Good morning, Your Honor.
Morning.
The document I've showed you is exhibit number 6, is the actual handwritten motion to impound that was filed by the defense counsel in front of Judge Locke on the morning of the 17th. Is that correct?
Appears to be this.
And would you please read into the record the reasons that the defense counsel cited to the judge for bringing that motion?
As reasons therefore, under the Uniform Rules on Impoundment Procedure, the defendant's right to a fair trial could be at risk from prejudicial pretrial publicity should these records not be impounded.
Thank you. I want to read you something that was read in court yesterday and ask you if you agree with it. It is
Thank you.
from comment number 5 to the rule of professional responsibility, rule 3.6, which is entitled trial publicity. It reads as follows. There are, on the other hand, certain subjects that are more likely than not to have a material prejudicial effect on a proceeding, particularly when they relate to, paraphrasing, a criminal matter or other proceeding that could result in incarceration. These subjects relate to, and now I go to subsection 2, in a criminal case or proceeding that could result in incarceration, a statement given by a defendant or suspect. You agree that statements made by a defendant, particularly when they're in quotes in a public document, have a substantial likelihood of prejudicing that person's right to a trial free from unfair publicity.
Depends on the state.
And if the statement is salacious or could potentially subject the person to ridicule or public opprobrium, is that an appropriate subject for shielding from public view before the trial?
Yes.
With due respect to the commissioner who asked the question, is the statement, "My father is a judge," salacious? Isn't it true, sir, that the actual statement that was redacted is, and I quote, "My father is a fucking judge and he is going to kill me," end quote? Isn't that the actual statement?
From my memory, yes.
Do you agree with the statement made, and I'm reading now from Rule 3.8, comment number 1. A prosecutor has the responsibility of a minister of justice and not simply that of an advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice. Do you agree with that statement?
Yes.
The comment goes on to say, competent representation of the government may require a prosecutor to undertake some procedural and remedial measures as a matter of obligation. Do you agree with that statement?
Yes.
Goes on to say, applicable law may require other measures by the prosecutor, and knowing disregard of these obligations or a systemic abuse of prosecutorial discretion could constitute a violation of Rule 8.4. Do you agree with that?
I believe so. I don't know what Rule 8.4 is.
8.4 is the rule that says conduct otherwise adversely pertaining to a lawyer's fitness to practice law. And in comment 6, it goes on to say about the prosecutor's duty to control others who are on the prosecution team. It says, I don't know if you agree with this. In addition, paragraph F requires a prosecutor to take reasonable steps to prevent all those assisting or associating with the prosecution team, but not under the direct supervision or control of the prosecutor, including law enforcement personnel, from making improper extrajudicial statements. Do you agree with that?
Yes.
You were asked a question on direct examination, I believe, about whether you as a prosecutor had ever made redactions to an arrest report. Do you recall that?
I do.
But isn't it true, sir, that when you were a prosecutor, the uniform rules of impoundment didn't exist, did they? They came into effect in 2015?
I saw that. I don't know if there were other rules that were in effect at the time. I don't recall.
My question for you is, isn't it true that the uniform rules of impoundment, which came into effect in 2015, favor redactions over impoundment?
I believe that's true.
And that was not the state of the law at the time when you were an assistant district attorney, was it? We used to impound things and not redact, right?
I can remember redacting things at trial. For example, with someone's in medical records. And there were areas in the medical records that were sensitive or revealed diagnoses that really had nothing to do with that particular trial. But that information should be redacted.
Now, you were asked some questions on direct examination about your understanding of what it was that Mr. Keenan had said, right? Okay. And I just want to make sure I understand this correctly. On direct examination in response to Ms. Pruitt's questions, you were telling us your memory from 4.5 years ago of what you understood, Mr. Keenan understood from a conversation he had with Mr. Travers that you weren't there for. Is that right?
Objection.
No, you can have it.
Is that a fair statement?
If I understand you, yes.
You're a judge and your business is judging, right?
Yes.
Would you agree with me? That's a pretty slender reed to make a judgment on.
Objection.
That's sustained.
That's. What's a null pros?
All process is believe it's Rule 16 of the Rules of Criminal Procedure. Motion to dismiss by the prosecutor.
Do you agree with me that Mr. Travers could have dismissed this case? Case against Ellie Meacham?
Generally, it's called a motion to dismiss in the rules. But when you read, that's what it's called, that's what it's titled. But when you read the body of the rule, it talks about an all pros, which is within the total discretion of the district attorney.
And if they had done that, as far as you know, based on the motion that you saw, that would have continued the impoundment in the case that had been dismissed, correct?
I'm not quite sure of that.
Okay. But you also agree with me that they could have started a new case based on the new report, correct?
The district attorney has the authority to null pros the case, which means terminate the prosecution.
He also has the authority to commence a new case based on the revised arrest report, right?
That's correct. I mean, they'd have to have a probable cause determination first.
But they had a revised report, right?
I don't know if they got a revised report.
That's fair. Now, I don't want to ask you any questions about your deliberative process, okay? But isn't it a fact that you allowed the motion to redact?
I allowed what I believe I allowed. I was allowing them to file a redacted version of the report.
And that took certain material out of the public view, correct?
Yes.
Okay. Isn't it a fact that you discussed that and got the approval of Judge Dawley before you did it?
Yes.
Isn't it a fact that Judge Locke allowed the motion to impound?
Yes.
And isn't it a fact that Judge Aled Madaus, when he looked at the police report, said, and I quote, "Jesus, they put that in there," end quote, or words to that effect?
That's my memory, yes.
It's 4 judges. That acted in the context of the public statements that appeared in that police report, correct?
The only ones that acted in the judicial capacity was Judge Locke and myself.
And words were spoken about what was in that report from Judge Dawley and Judge Aled Madaus, right?
Yes.
Part of being a judge is you have your own affirmative obligation to take steps when a lawyer crosses an ethical line, correct?
Correct.
You're a mandatory reporter when a lawyer crosses an ethical line in front of you, right?
When a lawyer or a fellow judge does.
That's part of the canons of responsibility that bind you as a judge, correct?
Correct.
Isn't it true that at no time in connection with your proceeding, well, actually, let me ask you, have you had any questions with the actions of my client, Jeffrey Travers, when he appeared in front of you, have you?
Whether he was doing something improper?
Yes, sir.
No.
In connection with this matter, you never felt that he crossed any ethical line, correct?
Correct.
That's all I have, sir.
How long would you be? Because I'm thinking we perhaps should take a morning break, but depends how long you're gonna be.
I won't be long. If I could just have a moment with,
Sure.
it's supposed to be like 10 minutes and then come
Okay.
back.
Do you wanna
I
take
don't
a
expect
break?
you long.
You're okay? Okay. Does anyone want to take a break?
They want to take 10 minutes, it's fine with me.
Yeah, we just want to take 10 minutes.
Oh, you want to take a 10-minute break?
Yes.
Oh, okay, okay,
Please.
okay. Why don't we
We don't
take, we'll take a short break.
We don't have a lot.
Okay, okay, thank you.
Thank you.
So we're talking about noon, Judge?
Yeah, good. Okay, thank you for appearing.
Thank you. Actually, what we were thinking was that we would move to have Judge Despotopoulos' AG interview moved into the record. My brother counsel cited to it, quoted to it liberally under the doctrine of completion, and then we wouldn't have any completeness, excuse me, and then we wouldn't have any redirect.
I'm
I
inclined,
actually believe it might be on his disputed exhibit list.
Well, I certainly would, Judge.
okay, and why are you objecting?
Well, because if they have questions about his testimony,
Okay,
the person's here.
Okay,
That's the
I-
evidence, not
okay,
just- Not what he said 4 years ago.
okay, well, yeah, Mr.
I also object, and I'm gonna object to any of the transcripts. And later on, we'll get into more detail on why, but specific position they took with Mr. Keenan yesterday was we can't put in his interrogatory responses, we can't put in his statements because he's here testifying. Now what they wanna do is put in the interview statements so that later on, they can cut and paste and use little snippets that we won't have a chance to have the judge address.
Okay,
And that's been going on since day one. And that is, this creative writing exercise where people take snippets of things and then try to do a new narrative of what's happening.
Okay.
And the problem is how it's being used, and I strongly object. If the witness is here, those statements shouldn't go in. If they have an issue about a statement he made, then he should have the right as a judge and as a human being whose reputation is important, to address it and not get blindsided by it in a brief 7 weeks from now.
I take it that was Mr. Keenan's statement admitted?
No,
Someone going to move to admit that?
no, they objected to it, and I said, fine, he's here, and I did the direct examination, I did my cross-examination without it. I referenced it a couple of times, but it was not put in evidence. Judge, this business of cut and paste after the testimony is just unfair.
Okay.
Everybody's, we started this case with a $450 expert about how important people's reputations are. Well, 4 respondents' reputations are important too, and a judge's reputation is important. And he ought to have the right, and we ought to have the right to have this case tried here and not on a cut and paste basis 7 weeks from now. That's
Okay.
what's gonna happen.
Okay, I what I'd like to do is address this after the judge testifies to allow him to leave. Yeah, what do you want to say?
Yeah, but Judge, he's here.
Right.
And what you're doing then, if you allow the introduction of his prior statement, they have the right to use that for impeachment if there was a basis to use it. There isn't. His testimony is consistent with what he said here. And same thing with the AG's report. You would then let it in for all purposes, including the substantive truth or lack of truth to whatever was said. That doesn't give us a chance to cross-examine. If they have something there that they want to use the document for, there's a specific rules-based predicate for them to use it for. They're not. I mean, you can't allow that to come in here without us having the opportunity to cross-examine him on the issues they're using it for.
Well, you know what's contained in the transcript, and if you want to ask him questions about that, you're free to. So I'm inclined to allow it in because I've allowed just about everything in, including if you want to get Mr. Keenan's deposition in, I'm inclined to let that in. So, and then I think we're smart enough to ferret out any prejudice that you're alluding to. Yeah, Ms. Kiley.
I do want to be heard. I used this transcript today after the witness indicated that he had read it in preparation for today's testimony. I did not introduce this. I asked the questions that I wanted to ask based upon his testimony as it related to the things that are referenced in here. I didn't address everything that is in the report.
Okay.
And think that when we have witnesses who are here, who are testifying, we all ought to be abiding by the same rules.
You know, as I indicated at the outset, I mean, once again, I'm speaking, keeping in mind all of my other commissioners and their thoughts and views on this. So I'm inclined to let it in, frankly. So I'm inclined to let Mr. Keenan's in, and frankly, the fears you have about them cutting and pasting, you know, candidly, I'm not concerned about it. I understand you're concerned about it. I think I'm smart enough, my fellow commissioners are smart enough to realize what's happening. And obviously, if they attempt to do it, if they do it, you know, you're filing your brief also, and you can draw our attention that it's unfair.
But it's also about people's reputations. And I think the judge sitting here today has a right to answer any questions and talk about anything he said in an interview, and not have it taken out of context and not have a snippet put in a brief. And I feel my client has the same thing too. He was here yesterday prepared to answer any questions. Well, you know what's gonna happen, and everyone in this room knows what's gonna happen. 7 weeks from now, he's gonna get ambushed in a brief, based not on what happened here, but on some snippet taken out of context in some interview. That's not a fair way to deal with people's reputations. It's not ethical.
Well,
It's not, Judge, I don't wanna belabor this, I'm sorry.
Yeah.
But, you know, I understand the rules and adjudicatory here, at least I think I do.
Right.
Okay, and I understand that, you know, hearsay and information is admitted in much more general basis. But you have his state, it's not just his state we're talking about. We're talking about other individuals who were interviewed by the Attorney General's office. We're not there, we don't have the questions, we don't know what it was, we don't have the chance to cross-examine it. It's no different in some respects to the content of that arrest report. You're allowing in information that should not be introduced in, whether it's an adjudicatory hearing or some other form of hearing, because we don't have the opportunity to cross-examine. I don't know everything that this witness said before the Attorney General's office. We can't proemptively or preemptively evaluate what's there and try to anticipate how they're going to use it. He's a live witness. If they want to cross-examine him with something that's in there, they should be doing that, not just putting in something piecemeal. That's not fair to us.
well, I appreciate that. So,
If I could just join,
No, wait,
I just wanted to join in the objection if I may, because this prior transcript, if there are questions about that, if they're going to point out inconsistency in that transcript, what the judge said today, the judge is entitled to be asked about that. Why was it inconsistent, as opposed to after the fact, it being pointed out that the transcript was inconsistent with what he said at trial. So I just think it would tend to be prejudicial to the witness.
okay,
With all due respect, and I apologize, I don't want to interrupt. With all due respect, he's our witness. There's no value in our attempting to impeach our own witness with his own statement. So that's not a real concern. Well, it's not a concern that with all due respect,
okay, hold on,
with all
yeah.
due respect.
I don't see that the
Excuse
commission would
me,
make that
and I
statement, it may be
believe-
another part.
Wait, hold on, one at a time.
Excuse me,
Ms.
please.
Yeah, Ms. Pruitt.
Thank you. Also, the question of prior transcripts and prior testimonies were dealt with on day one of this hearing through a series of motions in limine that the presiding officer has already ruled on, including interrogatories, not interrogatories, excuse me, depositions by question regarding Mr. Keenan, which my brother counsel argued in favor of and which were allowed in the record, including the transcript of Ryan Sevier, who was here and who testified, and yet his transcript was allowed in as well. We're only asking that we be given the same consideration, that it's consistent with what the presiding officer ruled on day one of this hearing, and that the transcript be allowed.
And so, yeah, hold on, one at a time, Mr. Sullivan.
You're right, I would distinguish this from any other witness. The judge is entitled to be confronted with anything, and it may not be the commission, it may be other counsel who raised an inconsistency. He's entitled to be confronted with anything from that transcript that contradicts or allegedly contradicts anything he said today. The purpose of the interview with the Attorney General was that they were investigating a crime. The judge had a duty during that interview to be as forthcoming as possible with respect to anything he knew that might lead them to the discovery of admissible evidence. In this case, he's answering specific questions. It's a much more limited examination. And I just think that the distinction is important. I think it's prejudicial to the witness if his transcript with the Attorney General is admitted into evidence here.
Okay. So, yeah, Ms. Burrows.
Just to bootstrap on that, the Attorney General's statements on investigation was not under oath. When we talked about, if you use Sevior's testimony here, I used a portion of his testimony, allowed him to read it, allowed him to have a chance to review that segment, 4 pages that I read. His interview spanned 90 pages. I cross-examined him legitimately on prior inconsistent statements that we used and confronted him with. You can't do that not just because he's a judge, because of any witness here. It's just inherently unfair to allow the introduction of documents that were not presented here in accordance with the introduction for the purpose of impeachment.
Okay, well, what I'm gonna do is I'm gonna withhold my decision until I have an opportunity to review what his statement was. And it was under oath and not under oath. But
It was not,
before-
Judge.
It was not under oath before
Correct
the
me if I'm
Attorney General.
wrong, Judge.
It was not under oath.
Okay, so it was not under oath.
None
Okay,
of them were.
okay, well, yeah, Ms.
I
Scott.
want to bring a procedural point up to you, Your Honor. There is a provision for witnesses, for people whose reputations might be affected, to appear before the commission in the commission statutes. It's in chapter 268B, section 3G, I think.
Okay, well, we're gonna have to check that out.
So from what it is that you're hearing from the witness and witnesses counsel, there is a provision you should take into consideration.
Okay, so I'll review that and I'll review his transcript and then I'll act accordingly. But I'm just gonna ask Ms. Pruitt to bring out the salient parts of the transcript in your redirect, that she's correct, it's her witness of her redirect of this witness.
Okay, so actually, I just want him to read, because my brother counsel brought in his AG transcript.
I want to stay there just for the
Sure.
microphone purpose.
Sure,
Yeah, thank you.
Sure. I just want him to read a portion of his AG interview into the record.
And
And it's short.
okay, go ahead.
Page reference, please.
Can you just,
It's page 24. And it is.
so it's, Ms. Pruitt, it's page 24,
Yep.
and we're on page 24? Is it lined? I
I'll
just, I
show
want to
them
make
all,
it
but I
easy
think
for everybody.
everyone has that section highlighted. If I may, sir? So starting on line 10.
Okay, so thank you. Okay, so she's gonna ask him to read line,
Starting at line 10.
okay,
Thank you.
Can I just ask,
Please.
is this being introduced for the purpose of showing a prior consistent statement or a prior inconsistent statement?
I don't know why you are,
Consistent,
probably a consistent statement.
please. Sir, if you could.
I think we were standing right at the entrance to the conference room, to that conference room. Brendan informed me that First Assistant Jeff Travers had wanted to file a redacted version of the statement of facts in the judge's daughter's case. And Brendan had told him no, and then Joe Early said, why can't we just change it out? It's redacted. They redacted statements.
Thank you. Okay, I have nothing further. Thank you.
Nothing further? Okay, okay,
Can I
thank you.
actually follow up on that?
Oh, I'm gonna give everybody an opportunity. Yeah, sure. Ms. Work, do you want to, help me start that?
This afternoon.
He's right.
That's why you're a judge. So, assuming that was your prior statement, consistent statement, however it was phrased. So the question, as I understand it, was asked, can we just swap one of those for the other?
Objection.
My language was changing.
Okay.
Yes.
As a judge, is your preference to have this done in open court?
Absolutely.
Indeed, that was this done in open court?
Yes.
Whatever the lingo or language or how it was presented to you, was this done in the auspices of a courtroom, in open court, where there's a transcript and record of it?
There's a record of it, an audio record.
Whether there's a transcript or not, there's an audio.
There is a transcript. I was shown one the other day.
Okay.
By Ms. Pruitt.
And that's done in open court, wasn't it?
Yes.
Anything inappropriate about that based upon your experience as a district attorney?
No.
Thank you.
Ms. Scully.
Ms. Pruitt had you read a portion of a statement. I would like to pick up with the line where she stopped. I'm going to hand you the relevant page.
Oh, thank you.
The relevant page is page Bates 1939. I'm going to direct your attention to the passage that starts with line 15, where you read from Ms. Pruitt. And I'm going to ask you to complete reading from where you left off.
So this is on line 17. I think the reason was that the statements had nothing to do with probable cause. The issuance of probable cause. Brendan Keenan said we couldn't do that because the original was what they based probable cause off of. And it contained those statements or words to that effect. I said we weren't going to do that. You can file the redacted, we're not switching them out. And then that was about it.
So your vocabulary, as you said, your words have changed. But what you were speaking to then was words to that effect in December, correct?
Yes.
And when you testified today, it's words to that effect, correct?
Yes.
And as you sit here today, you can't tell us what the exact words were that were spoken, correct?
I agree with that.
What you can tell us is that nobody ever presented you with a revised report and asked you to accept.
That's correct.
All of the discussions with you related to redaction, correct?
Yes.
And you allowed the motion to redact, correct?
Correct.
I want to take you to 2 pages later, to page, what will be 27. Move that podium. I'm going to direct your attention to line 14. I'm going to ask you to read the answer that you provide at line 14.
And the reason they were redacting it, as Mr. Travers told me, and I think Joe Worley told me, is that these statements were, I don't know, gratuitous, salacious. I'm not sure what the word was, but they were unnecessary to the finding of probable cause.
And then you get a response from one of the questions, yeah, and then you continue, do you not?
So the response was okay. Then my statement on line 20. So they didn't think that it should stay in there. And I think we were on the record that Mr. Travers said pretty much that under their duty to avoid prejudicial pretrial publicity, it was their view that they would remove, I think, sensational, and I don't recall whatever the words were. It had nothing to do.
And that's essentially where that page leaves off.
That's what the page ends, yes.
I'm going to read from, I'm going to read from page 28. It had nothing to do with the probable cause in line 1, period. That was what your statement was then, correct?
Yes.
That's still your statement today, correct? Statements had nothing to do with the word redacted, had nothing to do with the probable cause.
I'm gonna object. Is he asking him if it's his statement, or is he asking him whether Jeff Travers ADA Travers and or DA Early made that statement?
You have the question read back.
Yeah.
And it's still your statement today, correct? Statements had nothing to do with what were redacted, had nothing to do with the probable cause?
I agree with that. That is my statement in this transcript.
Thank you. I have nothing.
Okay,
Nothing further.
okay, thank you. Ms. Rusconi, you have anything?
Briefly, yes. Good afternoon, Your Honor. In my advanced stage, I omitted a line of questioning regarding some court procedures, if you don't mind if we revisit those. So you're familiar with the bail statute, right?
Yes.
276, section 58. Yes. You're aware that there is a presumption of personal recognizance to a defendant, and that is to say that absent certain factors, a person is presumed that they will return when they're supposed to their court date without having a bail imposed on them, correct?
Correct.
And the purpose of cash bail is solely to ensure that person's appearance in court, correct?
Correct.
Now, you've, again, handled several arraignments, I'm sure. An OUI first offense, for someone with minimal to no defaults, would you agree that that is common practice for that person to have a presumption of personal recognizance?
Yes.
Now certainly there are aggravating factors, criminal history, whether that person attempted to flee, but absent anything else, pretty vanilla that someone gets personal recognizance on an OUI first offense, whether it's a crash or not, right?
Yes.
And even on an OUI second offense, again, if there's no indication based on that person's record or history that they will not appear in court, they are presumed to have, they are availed of the presumption of personal recognizance, correct?
Yes.
So that is to say, it's not common for someone to place a cash bail on an OUI first or an OUI second, unless that person has a history of not showing up for court, correct?
I've seen bails on people first offense OUIs.
But in those circumstances, the factors for the bail would go beyond something that would say, let me rephrase that. When a bail is placed, there's a reason for it, and the reason is that there is a question of whether that person will appear in court, correct?
That's the basis of bail. Yes.
So, and again, I'm just doing this so everybody is on the same page, and for those watching as well, that unless someone has a history of defaults and an extensive criminal history, fairly common for an OUI first offense to have personal recognizance, correct?
Yes.
I have no further questions.
Okay, thank you. Mr. Bourgeois?
Thank you. So going back to the question, the section of your testimony that Ms. Pruitt had you read, beginning at line 10, what you read was, quote, "I think we were standing right at the entrance to the conference room. Brendan informed me that the first assistant, Jeff Travers, had wanted to file a redacted version of the statement of facts in the Bebo case." That's what she read, that she had you read, correct?
Which, yes.
And that was in fact your testimony or your statement to the Attorney General's office, is that correct?
Yes.
And so, and can you tell us approximately how long after the events that testimony was?
I think Mr. Kiley said it was December 8th,
December 8th?
2017.
So it was about 2 months after, is that right?
Yes, roughly, yes.
Okay, would you agree with me, and I'm sure you've heard this question a million times, your
Yes.
memory was better then than it is now, correct? Right?
Certainly.
And the verb that you said Mr. Keenan used about my client's request was to, quote, file, end quote, a new report, not swap, right? That's what you said.
Whatever I said.
And what you said was, I quote, Jeff Travers had wanted to file a redacted version of the statement of facts. That's what you said 2 months afterwards, right?
Correct.
That's all.
Okay, thank you. Mr. Sullivan, I just want to draw your attention. Mr. Kiley was correct in his citation. 268B, :4, subsection G, reads that, any person whose name is mentioned during an adjudicatory proceeding of the commission who may be adversely affected thereby may appear personally before the commissioner on his own behalf with or without an attorney to give a statement in opposition to such adverse mention, et cetera, et cetera. So I'm just going to ask you to just review that section. That's 268B -4 subsection G. So just review that and then feel free to either appear here or just file something with us about your thoughts are on the petitioner's motion to enter that
Thank
evidence.
you very much.
Okay. Okay, and how much time will you need? There's no rush. How much time will you need?
I would think maybe next week.
Okay, yeah, that'd be good if you can get it, by Wednesday if possible. Okay, so that would be good. So no other questions? Thank you, sir, for appearing here. I know it was inconvenient, so I thank you.
Thank you.
Okay,
Thank you, Judge.
have a good day. Thank you. Oh, yeah, thank you.
Thank you.
Mr. Travers, did you get back to Ms. Duca that information you wanted, the professional rules? You asked her, did you return it to her? Okay, very good. I had the larceny complaint out, so thank you.
I'm Mr. Bourgeois, he's Mr. Travers.
Okay, oh, I apologize.
Thought he was Judge Travis.
That's right.
That's okay.
So, petitioner, is it, at this juncture, you're going to move to introduce certain documents that we
Correct.
discussed the last
We've
couple of
already
days?
discussed.
Right, okay.
So, and I've already provided, I believe it was 2 days ago, I provided the respondents with this list. So this is our exhibits post your rulings on the motions in limine last Wednesday. First, I have the AG office interview transcripts of Jason Conant, Robert Johnson, Dean Ricciardi, and James Fogarty.
Okay. And that would be exhibit,
3, 24, 25, and 26.
I think 24, I think 23 is being held for that police report that's being redacted.
No, that's 22.
So we're starting with 23.
Okay. You're right, 23, sorry.
Judge Travers, just a quick second here.
oh, sure, sure.
They're part of the administrative record.
We hold off for a second while we consult.
Oh, sure.
Given, I know the court's ruling
Right.
on what we've discussed, but I have said to you all along that I have objections that may be separate from the rest of my co-counsel. And I have to tell you, Judge, based upon what just happened here today, and based upon the attempt to use the judge's, a portion of that statement, which obviously was then countered by the law of completeness by having Attorney Kiley go through the components of it that obviously put it in a much better context. I am renewing an objection or forming an objection to the introduction of these 4 individuals. And again, they were not under oath. They were not and do not allow me, and in particular have dealings with my client, the opportunity to cross-examine them. I have said this right from the beginning, so I am telling you that is my objection. And it becomes even more pertinent and poignant given the fact that this was, I think, if we had not made those objections, this, the judge's report, information would have been introduced wholesale. And whether you agree with what Attorney Bourgeois has said, it's exactly what took place. It was taking taking a statement out of the context and using it for the purpose of trying to impeach or demonstrate something contrary to what the judge's actual testimony had been. I object to the introduction of these 4.
Well, I guess the only thing I can say is you're free to call the witnesses if you want.
Sure.
You know, if you,
Okay.
you know, and given that their petitioners' witnesses and statements, I would allow you to cross-examine them if that's what you want to do. So I'll leave that to you, to all of you, to do that if you so wish. So next, Ms. Pruitt.
Next, I have October 19th, 2017 text messages between Susan Anderson and Daniel Ristine. Text messages between Jeffrey Travers and Joseph Early. Text messages between Jeffrey Travers and Ed Karsikanis. Text messages between Jeffrey Travers and Roberta O'Brien. Text messages between Edward Karsikanis and Roberta O'Brien. So I think that's beginning at exhibit number 27. That's correct, right?
Does anybody want to be heard on that?
I didn't object to them at the time. And with respect to the motions in limine, my memory is this: you gave us indications you were going to be allowing them. I think I pointed out that we had a period of time to respond to the motions in limine. We were doing it on short. So I don't think you've finalized, but you certainly indicated to us that what your leanings were going to be.
Okay.
And I did not object to this particular set.
Respectfully,
Ms. Pruitt, I don't think there's,
Okay.
you don't, you know,
All right.
sometimes silence is golden.
I'm gonna give you one document too many, sorry. I'm also putting in.
I just asked you to, so
I
for the
apologize.
microphone.
The next document, and I believe it's exhibit 32, is that right?
That's correct.
Okay, that would be the AG's letter to the enforcement division. I believe that the email from Sarah Adamson is already in evidence, is that correct? Is that exhibit 15?
15.
15,
Yes.
great, thank you. So we don't need to put that. So, exhibits 33, 34, 35, and 36 are the sworn interviews of respondents Travers, Early, McKeon, and Anderson.
May I ask a question?
Sure.
Does the Travers interview include the errata sheet we gave you?
No.
Yes, I object.
Oh, why don't you just put in the errata sheet?
I'll have to do that. I don't have it handy here, but I'll have to
Okay.
print out a copy.
Okay, so I will, so I'll admit that.
And I renew my
Sure.
objection for the reasons stated. I
No.
don't think it's fair.
You know, your objections are noted and your rights are saved.
So Judge, am I,
Wait, can you hold on one
sorry,
second?
sure.
So, uh,
well, she marks them then.
but before you do, are you ready to proceed?
Yes.
Yes? Okay, so Ms. Burke, what do you want to say?
So do I understand that they're introducing the under oath statements,
Correct.
interviews that were given
Yes,
for all purposes?
yes, I would assume so, yes.
Okay, I just wanna make sure everybody's was under oath.
Yes,
That we're
these are the
talking about?
sworn interviews of
Got it.
all of the respondents under oath represented by counsel.
For whatever the purpose may be apparent later on, I object.
Okay, well,
Yes,
Because they're going to be testifying.
okay, well, let's,
And again, I just wanna say that it may be a little different because they responded. But if there's issues about using them for some purpose other than for impeachment, they're going to be live witnesses.
I realize that, yeah, I realize that. Ms. Kiley,
you know,
brief and to the point, so, okay.
Commissioner, we would like to renew our motion in limine to admit the 2017 salary information. I believe you held your decision on that in abeyance.
Correct.
As we indicated, it is a matter of public record. It is on the comptroller's website. We'd like to introduce it into evidence.
I think you already got at least one of those in through one of your witnesses. I can't remember which witness, but you elicited from one of the witnesses, how much do you make? And the witness indicated how much he made. I can't remember what witness.
I mean, you could also take judicial notice of it. Yeah.
You know, well, all I'm saying is that the evidence you want is basically in for at least one of those witnesses. And I know the other part, did the respondents want to be heard on that?
I'll just repeat the same arguments we made before.
Yeah,
Rich,
okay.
but I don't see how this factual change has been made from the initial group.
It's, you very well might be right.
I filed a written opposition, and as you noted, I think that the question of substantial value is measured on the basis of what it is that is received, not the cost of providing it. These are public officials that we're talking about. Their jobs are to do as their jobs dictate. It's not something that they're giving to in this case, a respondent, a non-respondent. So that's the legal argument. I think you've actually heard some evidence from two witnesses. I think it was the trooper, and I think we heard it from a subsequent witness as well. I think you've heard it from two.
I agree.
I think you heard it from Mr.
Well,
Keenan.
as I said, while I may agree with you, I'm not deciding only for myself, but I have to take into consideration my fellow commissioners, so I'm going to,
And I want them to hear me too.
and I think they already have, candidly, and they will continue to hear that. So over your objection,
May I be heard on that point?
absolutely.
Somebody once said, and I think it was Brandeis, that the point about an arbitrary line is that it has the disadvantage of being arbitrary, but the value of being a line. $50 is $50. To use a homely analogy, a gift of a $30 bottle of wine is okay. A gift of a $60 bottle of wine is prohibited. But under petitioner's theory, we take the $30 bottle of wine, we add in the cab fare to and from the liquor store, we add in the cost of the gift wrapping and the bow, we get it over $60, and now it's prohibited. The value of the wine is lost. The theory has no support, and it's contrary to the whole point of the regulations. It's hogwash.
Your Honor, I would just object to the salary based on, if we're admitting evidence is supposed to assist the trier of fact. I don't see how somebody's annual salary, their overtime pay assists the trier of fact in trying to break down exactly who, what, where, and what occurred to generate this numerical number to get over $50. I think that would tend to, I don't see how that adds or assists the trier of fact in making a determination.
As I said, I very well might agree with you, but in deference to my fellow commissioners, I'm going to let them weigh in on this also, and I appreciate the arguments. So, and also I know that it's already in, so, we're beating a dead horse here, so, okay.
So we're putting in the payroll information of Daniel Ristine, Ryan Sevior, Francis Hughes, Brendan Keenan, Jeffrey Travers, Joseph Early, Richard McKeon, and Susan Anderson.
And that would be one exhibit, I take it. Okay, thank you.
One exhibit?
Well, don't you think it's better if one exhibit, it's with, but if you want to put them in separately, I don't care.
One exhibit. Exhibit 37. May I have a moment, please?
Yes, thank you.
How big? That's not gonna, that's not gonna do it. Okay. Okay.
That's all that we have at this time. Commissioner, I have a copy of Judge Despotopoulos' interview with the AG. You said you were
Yeah,
gonna
that'd be
review it,
great,
so
yeah,
if
and-
I could
yeah,
give
sure.
this to you.
Thank you very
All the
much.
respondents have it.
I'm gonna review this, I'm gonna wait for
Sure.
Mr. Sullivan.
Correct.
And you all have copies of this, right? Yeah, you all, okay, very good, so I'll some reading for me. Okay, is that it, Ms. Pruitt?
You have to say the words.
I'm looking at my co-counsel.
Yeah.
Thank you very much.
And nodding yes, giving you a thumbs up, so I take it the petitioner rests. Ms. Moran?
Yes.
The petitioner rests.
Okay, thank you. Thank you. Mr. Park, you want to be heard?
I do. So Judge, as you know, this is my client.
Right.
My client is one of the few women who have achieved the status, you will, and the rank. Of course, it's only ironic that she's charged with taking part in a non-warranted privilege to somebody of rank, as the statute says. But what's interesting is the petitioner has presented nothing in the way of evidence sufficient to meet their burden of proof. And it is their burden of proof. She, as everybody knows, and there's been testimony here, operates within and is subordinate to those who are in superior command to her. She has worked throughout her career in a paramilitary organization, much in the way that lawyers have to abide by the deference and the rules of court, so does she. And you heard the testimony from the only witness who actually has any pertinent information to her regarding her alleged violation of the ethics statute. Say that, oh yeah, he too operates in a paramilitary operation. And he was obliged and obligated to comply with a lawful order. And there's no question that was a lawful order. Attorney General's office didn't find that this was an unlawful order to have those revisions made. There has been no evidence presented through any of their witnesses that this was an unlawful order.
I hate to cut you off. You realize I don't have the authority or the power to do what you want me to do. And I say that with, I'm sorry, I don't have that power. I wish I did have that power. I don't have the power to do it.
That doesn't, I don't think that prevents me from making a motion, does it?
I can't act on the motion. You can't, there's no motion for
Well, I'm
directed
addressing it
verdict.
to the other commissioners as well. Because,
Okay, so,
bear with me, all right?
Sure, no, go ahead.
All I'm asking for is 4.5 minutes.
No, go ahead.
Maybe three.
I just want you to realize that I just don't have the authority to do that which you want me to do. And what I could do is meet with which I've obviously can do, is meet with my fellow commissioners and decide it.
I think they need to hear it too.
And you're free to do it. Go ahead. Okay.
And again, I'm not arguing with you,
No,
I
I'm
am
not.
going
Go ahead.
but I took 3 minutes.
No, go ahead. I'm allowing you. I'm just noting that there's not much I can do as a presiding officer. Go ahead.
There's nothing that she did that was inappropriate. There's nothing that she did was overbearing. Sevier said she was polite, appropriate, empathetic, and explained to him that she was acting in accordance with a direct order. And that he, again, was given a direct order. There's no latitude here. And that is a requirement, and there's a case right on point that I've cited before, Gillespie versus the Department of State Police, in which Civil Service Commission found specifically, quote, the MSP has proven that it had just cause to impose discipline upon Trooper Gillespie for his failure to, in quote, promptly obey the lawful order conveyed to him by a superior. There's nothing different here. There's nothing they presented that indicates that she had any other responsibility other than to do what she did. And she's entitled to have her case dismissed, not out of kindness or empathy, but as a matter of law. They have not met their burden. Time's up.
No, I respect the argument, and I'm sorry that I don't have the authority to grant that which you, so.
I can't pretend not to know the rules of the commission. You do have the authority as a commission to reconsider the order that you made on summary disposition. The time for the petitioner to lay out its case, the time for them to put up or shut up, passed before we had this hearing. The motion was denied. I ask you to reconsider it with the panel, with your fellow commissioners. There has been an abject failure of proof with respect to the alleged violation of section 23B3. There is no evidence that there was an unwarranted privilege in play in this case. The supposed privilege relates to prejudicial statements in a document that was going to be public. There is no question, based upon the evidence before you and the panel, the members who have been listening, that rules 3.6 and 3.8 and the Constitution of the United States impose an obligation on a prosecutor to take action to prevent such publication. And there is no question on the evidence in this case that that is what it is that First Assistant District Attorney Travers asked whether to be done. There's no question that the motion was filed. It was warranted. Redactions, impoundment have a purpose. The purposes were served. To the extent that there is a further necessity to do something with respect to it, the idea would have to be that that privilege was not properly available to similarly situated individuals. There's no evidence to that effect. The idea that this case was unlike others doesn't mean, and you now have an exhibit that says it, that does not mean that it wasn't appropriate. Faced with a situation that called for some kind of action to be taken, the prosecutors had a duty to pursue it, and they had a duty to take reasonable steps with the state police who were working on the case to prevent the matter from the issues. The uniform rules that we've talked about impose an obligation on all persons to impound, to honor an order of impoundment. The order of impoundment was served on the state police. The matter was leaked. The matter was, a violation of law occurred. that resulted in a flurry of publicity. That's what the evidence is. That's the uncontested evidence. It was very damaging and proves the point to the pudding. The notion of substantial value on the 23B22 violation, again, the commission was given the authority to establish what the value of what substantial value means. You promulgated a regulation. It's monetized. The $50 is the definition. Sometimes the $30 bottle of wine, sometimes if I go to the wrong place, it costs me $60. A crazy notion that value is going to be established on that basis. But again, the elements on 23B3, B22 are just not met. And the commission should reconsider its decision. The elements on a 23B2 are not met in this case. The evidence in the standards require that a reasonable person, knowing all the relevant circumstances, would conclude that an individual would be more likely to act or fail to act based upon the standards that we've talked about, rank, etc. Major Anderson has no knowledge of these individuals. There's no indication of that there should be favoritism. Colonel McKeon has no relationship with them. First Assistant District Attorney Travers has limited exposure to them, very limited. There's no evidence of any kind of personal, social kind of relationship. And frankly, the evidence that is in with respect to Mr. Early and the family is also fails to meet the standard. But the relevant circumstances in this case have to involve the obligations, the special responsibilities of prosecutors. And the fact that exists eviscerates the 23B22. And that's a summary disposition matter, and that is something you can reconsider. Thank you.
Yeah, Mr. Moscone.
Good afternoon, Your Honor. Your Honor, I join with my co-counsels with respect to the arguments about substantial value with respect to unwarranted privileges, so I don't want to belabor that. I just will submit that again, renewing my summary decision argument. It's not an unwarranted privilege to have your rights preserved and protected. That's what's supposed to happen. I think that's pretty straightforward, and I don't think that's been disputed or changed since we started. With respect to Colonel McKeon, he issued an order down the chain of command, a lawful order, to have a report revised, paraphrased, to take out comments that were not related to probable cause and were salacious in nature. You have heard from several witnesses. You've heard from the Chief Justice of the Trial Division. You have heard from the First Justice of the Worcester Court. You have heard from the Clerk Magistrate of the Worcester Court, who has served for 47 years. It is not disputed amongst any of them that those statements do not relate to probable cause. That, in and of itself, suggests that everything Colonel McKeon had done in his order to revise those statements was proper. The petitioner has not presented any evidence that will refute that he has the authority to direct how investigations and reports are done under Chapter 22C. It is his legal authority. It is within his purview. In fact, in most cases, he's required to act pursuant to that statute. There has been no evidence up until now at all to suggest otherwise. I think that's a very important issue to reconsider for the Commission. And after hearing from Trooper Sevior, whose impression was that something was not being done properly or ethically or however he wanted to phrase. I think the word he used was nefarious. Appeared to have started with a quibble over bail. He suggested that he doesn't have to tell a bail commissioner anything other than what he told the bail commissioner, which was criminal history, limited defaults, or I believe there were no defaults, and he suggested something about an OUI with the crash is a standard $200 bail. No other person with a law degree has agreed with that assessment. Everybody who addressed the bail statute has said that ties to the community is something that must be considered, and it was withheld if you are to accept the testimony of the particularly Clerk Keenan. I suggest understands the bail statute quite well. He made it very clear that he would ask for that information, or any other bail commissioner ask for that information. It's necessary to make a determination of bail. That's why it was lowered to 0. Trooper Sevier had a difference of opinion on that for whatever reason. Trooper Sevier does not possess a law degree. He admitted he's not familiar with the bail statute. And from then on, his other representations of something nefarious happened have all been addressed. That a first assistant would never handle an OUI. It's not that he's handling an OUI, it's he's handling a transfer case. He's the one that handles all the transfer cases, whether it's an OUI or a shoplifting or a larceny or anything of that nature. The fact that it's an OUI first offense has no bearing on why the first assistant was handling it. Trooper Sevier has been a trooper for, at the time, less than 2 years. It appears he does not have consistent daily contacts with the court itself and the workings of the DA's office. So what he's doing is offering his opinion that something nefarious happened. That opinion is based on his limited view of the situation. He is not somebody in a position that has all the relevant facts and is aware of the situation. He is not in a position to make such an assessment. And you heard him testify that those statements should come in based on something to the effect of, well, I think it goes to state of mind. He conceded that that's not part of his training pursuant to the National Highway Traffic and Safety Administration materials and guidelines. It's not something that he should be considering in making an assessment on OUI detection by his own training. His own trainer echoed those sentiments that is not something that they train you in. You are not trained that a statement by somebody tends to show a level of intoxication. So while Trooper Sevier's impression of the situation, and it seems that his impressions are the only thing that have given rise to where we are today, each of those impressions has shown to be flawed or misinformed. And I'm not saying he didn't genuinely feel that way, I'm just saying he's not in a position to make an accurate assessment of those facts. So again, he suggested that he was somehow disciplined. That's not what happened. He was given an observation report, educating him without disciplining him, as the Johnson versus Downey court case, the Downey versus Johnson court case holds. And the testimony the only testimony that it was disciplinary comes from Trooper Sevier, which again, he is mistaken. It's not disciplinary. It's the easiest, most efficient way to say, hey, this is the way the department's going. Please don't do that again. And everybody else, don't do it again. It's not for any special individual. In general, don't do it again. Went through the chain of command. It was all above board. Everything that was done, starting with Colonel McKeon learning of the report, right up until the issuance of the observation report itself and the revision, paraphrasing of the statements was proper. And Sevier conceded the statement leading up until the quotes that I won't repeat about how that person acquired a substance, which again, every person with a law degree has said that has no bearing on impairment. He perfectly paraphrased that person had acquired a substance and was in possession of it at some point, despite the fact it still didn't go to probable cause. So I would suggest and I implore the reconsideration, particularly again, because under 22C, the colonel has the authority to say, this is the way we're going to do this. This is how I want the state police to be portrayed. I don't want young troopers going to courthouses and having somebody look upon them with some level of disrepute because of a statement that was unnecessary and in their discretion should have been left out for a probable cause statement that would be made public. For those reasons, I don't want to belabor the legal points that have been made already. I implore the commission to reconsider those arguments that were made today and for favor of summary judgment.
Okay, yeah, Ms. Bourgeois.
I think I'm gonna be shorter than everybody else.
Good.
I've been the guy from the beginning in this case that has suggested that different kinds of procedural approaches and different kinds of case management techniques, and now I'm gonna suggest another one to you and the commission. You do not need to issue your decisions in this case for all respondents on the same day. Because Travers particularly is in the unique position that when you look at the order to show cause against Travers, all of the possible proof has already been put in. And you can decide very quickly, without need to get to questions of substantial value, without need to get into questions of even unwarranted privilege. The petitioner just didn't prove what they alleged. And that is a matter of credibility. You never get to those points with Travers. Because if you look at the Travers order to show cause, paragraph 10, they say that on October 19th, Early told Travers to expect a revised arrest report. There is no proof of that. They didn't call Early and Travers said, that didn't happen. I was told some report was gonna come in. Paragraph 12. This is again, order to show cause against Travers. Early directed Travers to go to the district court and replace the original with the substitute. There is no proof of that. They didn't call Early. Travers said that never happened. Travers went to the clerk's office and attempted to replace the arrest report. You heard Travers' testimony? He said, I just asked him if he could accept it. You heard Brendan Keenan's testimony. I don't remember what he said. I kind of thought this, but I didn't think he crossed any line. You saw Judge Destatopoulos. His memory was, the word was file, not replace. You can sit as a commission and say, look, it's very simple. As a matter of proof, they don't have a case against Travers. And we don't even need to get to questions of substantial value or unwarranted privilege. We can get to those later. I ask you to do that. Because reputations matter. We started this case with a $450 an hour witness that my client, that told us something my client so painfully knows. Reputations matter. The reputations of these respondents matter too. And the earliest that this commission can clear my client's reputation, I ask you to please do it. Thank you.
I think what we're discussing now is whether I should ask my fellow commissioners to reconsider the previously filed motion for summary decision. Do you want to be heard on, Ms. McKeon?
On the, reconsider the motions for summary decisions?
Yeah.
Good afternoon, John McDonald for the petitioner. On that point, we would ask that motion to reconsider be denied. Those motions for summary decision were all extensively briefed. Everyone had the opportunity to say what they had to say. There was oral argument scheduled. They were briefed, they were argued, and those motions were decided. There's no need to reconsider those motions. We're here in an adjudicatory proceeding. We've had our case put on, time for the respondents to put on their case. So I would suggest that there is no need to reconsider the commission's decision denying the respondents' motions for summary decision.
Okay, thank you.
Thank you.
Yeah, what I'm going to do, I'm going to refer to my fellow four commissioners and see if they want to reconsider it. You know, there you have it. I can guess what their decision's gonna be, but assuming that it's no, I will refer it, I'll do it this afternoon. And presumably, I don't know what commissioners have been listening in. I know a few have. I don't know how extensively they've listened in. I don't know if they've all listened in, but I will pass along your motion to reconsider. If it in fact is denied, so where do we stand for tomorrow?
Some places we stood yesterday, I think.
What's that?
I think same as yesterday. I think we're gonna start with Mr. Hughes. Are we?
Yes.
Yes, Colonel, retired Colonel Ron Hughes should be our first witness.
Okay, the first witness will be Colonel, and that'll be tomorrow.
Right.
And I would anticipate if it goes as we anticipate that Chris Hodgins, Assistant District Attorney, would then follow.
Tomorrow. Okay, so 2 witnesses
And
tomorrow.
if it falls that way.
And we'll find out. I'll let you know. And the way we've been going, I've noticed typically when you put 2 witnesses in, that takes most of the day. So, that's the reality of the situation. So, okay, if that's it, it's 1:20. So if that's it, I'll just see everybody tomorrow. And as I said, I'm going to refer this, I'm going to ask Mr. Duca to refer your motion to my fellow 4 commissioners.
Don't think you're gonna see me tomorrow.
Oh, that's right. That's right, Mr. Bourgeois. So safe travels to you. Is your client going to be here? No. Okay, so safe travels and everybody have a good evening.
Thank you,
Thank you.
And we'll see you tomorrow. Thank you.